Hello everyone, I welcome you to this video in which we'll try and furnish an answer to the question, is judiciary a part of state under Article 12? When we looked at the definition of state under Article 12 in an earlier video, we realized that there is a silence that Article 12 maintains on the position of the judiciary. So though legislature and executive are included within the bracket of this word, the definition is actually silent on whether the judiciary is a part of state or not. And that's precisely the question that we will try to answer in this particular video. Now this question about whether the judiciary is a part of state or not becomes more interesting because of the unique and the peculiar kind of function that the judicial branch performs. The judiciary is engaged in discharging an adjudicatory function that is designed to basically solve a dispute between the parties that are before the court. So, the court does not, like the executive branch, for example, engage into some kind of actions that are going to directly impinge upon fundamental rights. And therefore, in the discharge of its judicial functions, can the judiciary in fact violate fundamental rights of the people? That's an interesting question that arises for inquiry. Now, if we look at the position in the United States of America, in the United States, there are sufficient judgments to suggest that judiciary is indeed a part of state that is subject to the limitation of the 14th Amendment of the US Constitution. In India, this question as to whether judiciary falls within the word state or not did arise for consideration before the court in a case called Budhan Chaudhary versus the state of West Bengal. But though the question arose in this case, the court did not furnish a concrete answer to this particular question. Though if one reads the judgment and if one looks at the observations of Justice Das, one would be inclined to conclude that the court did want to hold that the judiciary is indeed a part of state under Article 12. If one reads the judgment of Justice Das in this particular case, Justice Das has actually quoted a passage from the judgment of Justice Frankfurter of the United States of America, wherein Justice Frankfurter very concretely says that the judiciary in the United States is really subject to the 14th Amendment of the US Constitution. So though this question was not very concretely answered by the court in so many words, the inclination of the court's judgment, Justice Das's judgment in Budhan Chaudhary, was in favor of suggesting that the judiciary is a part of state under Article 12. Now, this question very categorically and concretely arose before the Indian Supreme Court for the very first time in a case called Naresh Sridhar Mirajkar versus the state of Maharashtra. So this was a judgment of the year 1966, and this question very concretely was before the court. It was a constitutional bench of 9 judges of the Supreme Court that was constituted, and 5 different judgments were delivered in this particular case. Now, before I come to answering the question or looking at the way the court answered this question, let's quickly take a look at what actually happened in Naresh Sridhar Mirajkar's case. This was a very, very sensational libel case that was going on before the Bombay High Court. And in this case, there was evidence that was being recorded by the court, and there was one Mr. Goda whose evidence was already recorded by the court before, and he was recalled for re-examination before in that particular trial that was going on before the court. Now this time, this Mr. Goda made a request to the court to issue an order prohibiting the publication of the evidence that he gives in the case or the proceedings of the case, he requested the court to issue an order to prohibit the publication of these proceedings in any kind of a publication, specifically in the newspapers, because it was his case that on earlier occasions when he came to give evidence and that was published, that actually affected him very badly. So it affected his reputation is what he had to say, and therefore he made this request from the court. Now Justice Tarkunde of the Bombay High Court issued an oral order prohibiting the publication of proceedings in this particular trial. Now, one thing that we need to very carefully note is that this trial that was going on was a proceeding in an open court. It was a public trial. This was not a case that was happening in camera. It was a public trial where members of the public could generally have an access to come and listen to the proceedings that were going on in the court. But Justice Tarkunde, on the request of Mr. Goda, issued an oral order saying that proceedings of this trial be not published anywhere. Now, the moment this kind of an oral order was issued by a single bench of the Bombay High Court, there were petitions that were filed challenging this order, and the basic contention, of course, was that this kind of an order could not have been passed by the court at all, and in any case it needed to be a written order. Justice Tarkunde refused to pass a written order, and when that was challenged, the approach taken by the High Court was that, look, in no case can a writ lie from one High Court to another High Court, or from a High Court to another bench, or even a single judge of the High Court, right? And thereafter the matter went up to the Supreme Court of India under Article 32 of the Constitution, and the people taking up this petition were basically journalists who claimed that, look, this kind of an order is violative of our fundamental right under Article 19 of the Constitution. Now, when this matter came up before the Supreme Court, it was referred to a larger bench, and as I said, there was a constitutional bench of 9 judges of the Supreme Court that had this question to decide in Naresh Sridhar Mirajkar. So you had 5 different opinions that were written. The majority opinion written by Chief Justice Gajendra Gadkar. Then you had concurring judgments that were written by Justice Sarkar, Justice Shah, Justice Bachawat, and Justice Hidayatullah, who wrote a dissenting opinion in this case. Now, what did the majority hold? The majority's holding in this case on the particular question of whether judiciary is a part of state under Article 12 or not, the majority says that judiciary is not state for purposes of Article 12. So it's not a judicial decision cannot really result into violation of fundamental rights of people, and therefore no writ can lie from the Supreme Court to the High Court in these kind of cases. Now, in the Mirajkar case, if we carefully go to look at the judgment, there were precisely 3 questions that were up for inquiry. The first question was, did the High Court at all have a power to issue an order of this kind? The second question was, does the impugned order result into violation of fundamental rights of the citizens under or the petitioners under Article 19? And number 3 question was, if it does result into violation of fundamental rights, does a writ lie from the Supreme Court to the High Court? Now, if we look at the approach that was taken by the majority in this case, so if one looks at the judgment of Chief Justice Gajendra Gadkar, what did Justice Gajendra Gadkar say? Justice Gajendra Gadkar in his judgment says that, look, this prohibition which came about with Justice Tarkunde's order prohibiting the publication of these proceedings, that was something which was meant only for the duration of this particular trial, or this particular evidence that was to be given by Mr. Goda, and it was not an order that was issued in generality. Okay, so he said it was something that was necessary for meeting the ends of justice, because somewhere we felt that the publication of these proceedings would come in the way. It would create obstructions in the administration of justice, because then probably we couldn't have the right kind of evidence coming in this particular case, right? But Justice Hidayatullah makes a dissent there, and he says that, look, whenever a court is functioning in an open proceeding where it's a public hearing that's going on, and the general rule is that whenever there's a public hearing that's going on, any member of the public can actually sit down into the courtroom and witness what's happening there. So whenever these open proceedings in an open court are going on, it would be incorrect for a court. The court does not have any kind of a power like this to issue an order prohibiting the publication of proceedings in an open court. So that was the take of Justice Hidayatullah, where he says that, look, there's no way that you can read any kind of an inherent power in the High Court to issue this kind of an order. And moreover, Justice Hidayatullah in his dissenting opinion tells us, he says, if one looks at the scheme of the Constitution in totality, nowhere do you come across the intention of the founding fathers to be excluding the judiciary from the purview of the state. Though the definition per se is silent, if you look at the constitutional spirit in totality, if you look at the Constitution in totality, it was never the intention of the founding fathers to exclude the judiciary from the limitations that fundamental rights impose on the actions of the other branches of the government, right? If we look at the question, which was the very important question that was to be answered in this case, that can a writ issue from the Supreme Court to the High Court for violation of a fundamental right through a judicial order? The majority says this cannot happen, because when the judiciary is exercising its judicial powers, when the judiciary is acting in its adjudicatory capacity, which in the present case it was, because it was a judicial order issued by Justice Tarkunde, the court says that, look, when the judiciary is performing its parental adjudicatory function, no judicial order can be conceived as one that is violating the fundamental rights of people. And that being so, because both the High Court and the Supreme Court are the constitutional courts of this country, you cannot conceive of, you cannot think about the Supreme Court having a power to issue a writ against the High Court, nor can a writ be issued by one bench against another bench. That was the take of the majority. But again, Justice Hidayatullah delivers in his dissenting opinion, he tells us that this was not the intention of the founders of the Constitution at all. So just like the other two branches of the state, even the judiciary is subject to the mandate of fundamental rights, and therefore, if a judicial order is resulting into the violation of fundamental rights, a writ would very well lie from the Supreme Court against the High Court. Now, this was the way the court looked at it, and of course the majority opinion became the binding law. So what was the takeaway that we had from the Mirajkar case? What the Mirajkar case concluded for us is that judiciary is not a part of state under Article 12. When it acts in its adjudicatory capacity, the judiciary cannot violate the fundamental rights of people, and consequently, therefore, no writ can lie from the Supreme Court to the High Court, or from one bench of the High Court to another bench for violation of fundamental rights. So that was the major take of the majority in the Naresh Sridhar Mirajkar case. But if one looks at, or if one reads the comments that Mr. Sirvai gives in his commentary on constitutional law, he gives us very strong reasons about why Justice Hidayatullah's dissenting opinion appears to be more correct, and that's the way we should be reading the position of the judiciary vis-a-vis Article 12 of the Constitution. I think the present day times give us more convincing reasons about why the judiciary should be a part of state, and how probably Justice Hidayatullah was right in taking that approach back then in 1966 when Mirajkar case was decided. Because today, if we go to look at it, let's look at the kind of powers that the judiciary uses. If we take, for example, the Vishakha case and many more cases after Vishakha, where the court went on to lay down guidelines in the absence of a legislative law. So these are cases where we are actually seeing the judiciary legislating like a legislature. So in terms of these kind of laws, new laws that the judiciary is creating, I think there is a greater reason to accept what Justice Hidayatullah said, that yes, the judiciary is also capable of violating fundamental rights of people. But be that as it may, if we try to look at what did Naresh Sridhar Mirajkar decide for us, the Mirajkar case gave us the law that judiciary is not a part of state under Article 12. Now, after Mirajkar, there's another case that we need to look at, and that is Antulay versus Nayak. Now, in Antulay versus Nayak, this was all a case about a trial that was going on in a special court under the provisions of the Prevention of Corruption Act. So that trial was going on in a special court created under the Prevention of Corruption Act. And in view of the long delay that was happening in the trial that was being there before the special court also, an application was made for transferring the case from the special court to the High Court. And such an order was actually issued whereby the case got transferred from the special court to the High Court. Now, this resulted into Mr. Antulay, complaining of this kind of an order that brought about a transfer of the case from the special court to the High Court, having aggrieved him in a way that he actually lost one right of appeal, because otherwise normally from the special court an appeal would have gone to the High Court, and then from the High Court it would go to the Supreme Court. But now the trial itself got transferred from the special court to the High Court. So there was a complaint of, this order resulting into a loss of one right of appeal of the appellant. Now, in this case, therefore, ultimately, this question boiled down to the same question we asked ourselves, that is the judiciary capable of violating fundamental rights of people? Now, interestingly, in the Antulay case, the court doesn't really go too much into what the Mirajkar law had decided in this particular case. So it does not look into what approach was adopted in Mirajkar and what was the conclusion of the court and stuff like that. The court does tell us in its judgment in Antulay that, look, no writ can lie from one constitutional court to another court. So there it was in line with what Mirajkar case decided. But then, despite saying that no writ would lie and therefore no judicial order actually violates fundamental rights, but the court still said that there was a scope for a court to correct certain errors in an earlier order, and that was sought to be related to the inherent powers of the court under Article 142 of the Constitution. So it said that, look, no writ will lie from one bench of the High Court to another bench, but nonetheless the court does have the power under its inherent powers in 142. The court does have the power to correct certain errors that may be committed by judicial orders. Now that was the judgment of the court in Antulay. So Antulay doesn't really in any way say that we overrule Mirajkar. But if you go to look at what factually the court went on to do, the moment it says that, look, we do have a scope to correct errors, and in this case it actually gave a relief to the petitioner before the court. If you go to look at the conclusion of the court and what it ended up doing, it probably tells you that it did overrule the Naresh Sridhar Mirajkar case. Though the court never says this in so many words, nor refers to the Mirajkar law, that's what the Antulay case brought us to. Now, after this, if you look at Rupa Ashok Hurra versus Ashok Hurra, that was a case in which the court invented a completely new kind of a remedy called as curative petitions. So somewhere we still maintain the position that, look, no writ lies from one constitutional court to another constitutional court. But in Hurra case, the court invented a new kind of a remedy called as the remedy of a curative petition, where it says that, look, again under its inherent powers, the court does have the power to cure some kind of errors that may be committed. And where you talk about these errors, the court is basically talking about violations of the principles of natural justice and things like these. When these kind of errors are committed by the courts, there's a scope for correcting those errors by filing something that you call as a curative petition before the court. So today, if you go to look at this question, is judiciary a part of state under Article 12, and can a writ lie from one court, one constitutional court to another constitutional court? You don't have concrete answers that are supplied to you by any case except the Mirajkar case, which categorically told you that judiciary is not state, no writ lies. Subsequent judgments also endorse the point that no writ lies from one constitutional court to another, but they do create pockets of new kind of remedies that they are inventing for correcting these kind of errors that may emanate out of judicial orders. So this is the position that we adopt today with regard to answering the question whether the judiciary is a part of state under Article 12 or not. The concrete answer supplied to you is only through Mirajkar, which tells you judiciary is not a part of state, but subsequent cases that talk to you about different remedies that have been invented for correction of judicial errors. Now, this was with regard to position of the judiciary under Article 12 of the Constitution of India. I sincerely hope this video benefits all of you in terms of understanding these cases and the laws that it lays down. Thank you very much for watching this video. Should you have any queries or any questions to ask, please do put that in the comments section. Thank you.
Please like this video and subscribe to our channel. For more such informative topics on constitutional law, please like this video and subscribe our channel.